On behalf of Sonia and Emily, I just want to welcome everyone to this 27th annual Constitutional Cases Conference. And when I say welcome everyone, I want to welcome everyone in the room. And of course, we have a large community online as well, which has been a wonderful innovation since pandemic. Thank you so much for coming. Your commitment to an investment in this event over the years means just a great deal to us. We value really deeply how this conference displays that profound, really delightful porousness between the academy, between the bar, really belies any strong distinction between the two, and how this always feels year after year as a space of sincere intellectual camaraderie and indeed friendship. And this really is our favorite academic day of the year. We collect this energetic, wonderful community of constitutional law nerds in a room together. We connect, debate, reflect on questions of constitutionalism and justice. And if anything, we've really come to value this day more and more in recent years, and a time at which spaces of positive, genuine connection feel a little bit more rare and precious in the academy. I think it's appropriate to pause here just for a second to acknowledge that there is an ongoing labor disruption at York. Come to think of it, also in its 27th annual year. And, but joking aside, it's a difficult kind of complex thing for us to manage. Having this downtown conference with a lot of different communities involved and an ongoing labor disruption at York. And I'm really not at all certain that we manage it as deftly as we might. I know I am certain that I'm channeling the sentiments of folks in the room when I say that I very much hope that we get a swift and fair resolution that properly values the labor of our academic colleagues in 3903. So as we embark on this year's iteration of the event, we're very much mindful that we're adding to deep traditions of thought about the nature of community, about relationships, of justice, and in constitutionalism generally. This is a tradition, that deep tradition, that in one frame has been anchored by generations of our Osgoode colleagues, constitutional scholars, the law scholars over almost 3 decades now. But that tradition of deep thought and reflection also totally exceeds us, because constitutionalism always exceeds institutions. It always takes place somewhere in regard to certain relationships, certain communities. And of course, this place where we're assembling and meeting today is a place of deep, of ancient constitutionalism. It's, of course, an area subject to the dish with one spoon wampum belt covenant, which is an agreement to peaceably share and care for this territory. And as we collect to think about questions of law, justice, community, in full recognition that we're latecomers to this territory, and therefore latecomers to this long conversation about constitutionalism, we recognize that tradition, inaugurated by the Anishinaabe Nation, the Haudenosaunee Confederacy, the Huron-Wendat, the Métis, other Indigenous peoples, and carried on for all of us now also by the Mississaugas of the Credit First Nation, the current treaty holders. And so we're really grateful to be able to hold this event in this place, rich with the challenges, questions, creativity that defines all projects of constitutionalism. Now, we used to go through the schedule for the day. I don't think that's necessary. You can see in the menu card of our intellectual buffet here, an incredibly rich program. It begins, as is customary, with the much anticipated year in review, this year delivered by one of my truly favorite constitutional law scholars, Kate Glover Berger. And we have fabulous plenaries, breakout sessions we're very much looking forward to, and have been looking forward all year to our keynote, Dr. Deborah Thompson of McGill University, who's delivering the Laskin Lecture, generously supported by the York Center for Public Policy and Law. So that's happening right in the middle of the day. But before I just move us along to the content of our day, just a few logistical and practical details. Needless to say, a reminder that proceedings today are being recorded. We are principally in this room for all of today's events, the way we've organized it. But for those of you who will be attending panel B this morning on punishment and policing, you are invited to the luxury suite just adjacent to us, one room over, for that one breakout session for the day. Timing is reasonably tight between sessions, so we're going to be asking chairs and speakers to also keep tight to the schedule. And for you, please move swiftly between the sessions. And here I'm specifically speaking to you, Sonia, to move swiftly between the sessions. Now, our custom is to keep introductions to a minimum. Bios of all speakers are on the website if you want to check that out, along with a kind of full back catalog of our issues of the Supreme Court Law Review on the Osgoode Digital Commons. We're very proud of that part of the conference, the long history of contributions that our speakers and guests have given through that special issue every year published in the Supreme Court Law Review. And we're looking forward to the papers from today, hopefully finding a space in our next issue. And that just brings me to a couple of other thank yous. A thank you to one of our sponsors, LexisNexis, who supports the conference, publishes that special issue each year. And a really sincere thanks to Osgoode Professional Development, led by Victoria Watkins, who's very generously supported the event as we've returned to this location. It really helps us keep ticket prices as low as we possibly can, which is something we value really deeply. While you're here, just to say that, be sure to check out, if you're interested, some of the specialized professional LLM programs, certificate, degree, diploma programs at OPD. And finally, if you have any questions, please touch base with one of us, with Sonia, with Emily, or me, or our exceptional research events coordinator, Erica Robinson, who you met at the front when you came in. Also, an in advance thanks to Tristan, who's running the tech today. Thank you for all you're doing. And let me just now turn to welcoming our Dean, Trevor Farrow. I'm about to hand things over to him for some words of welcome. Let me just note, this was Trevor's first year as Dean. We're really proud to have a scholar of his caliber, most especially a person of his quality as our Dean. I wish he had been dealt a more interesting year with more curveballs and events, but it was quiet. He's made the best of it as best he could. Trevor, we're really proud, grateful that you came for a few words today.
Thank you, Professor Berger. That was me moving quickly between. First of all, welcome everyone. As Ben said, my name is Trevor Farrow, and I'm just delighted to be here with you on the 27th Annual Constitutional Cases Conference, which I think is not lost on anyone. It really is a flagship program for Osgoode and part of our, what we think and are proud of, our deep history in thinking and teaching and policy debates around constitutional law and public policy. Welcome to our friends from across the country. I was talking to Tristan ahead of time. I think we've got lots of people beaming in, so great to have you here. And to our friends, again, from across the country and from locally here at OPD. So happy to see you. I do want to make a special mention also to my Osgoode colleagues here. And Ben mentioned the long tradition of folks who have also gone before, and happy to acknowledge those. I can't help myself but mention our colleague, Professor Jamie Cameron, who's I think online right now, would normally be here. But anyway, and so many of our colleagues, we're happy to be here with you. I too want to welcome our keynote and Laskin lecturer, Dr. Deborah Thompson from McGill, which I think everyone's looking forward to at lunchtime. Will be a terrific session. Ben also mentioned, I think, our commitment to that the debate or dialogue or what have you between the bar and the profession and policymakers. And that's one thing that I think we are so excited about at Osgoode, and in particular at this space. And so it's not, I do want to take a moment when I'm thanking our OPD colleagues, but also to give a shout out to this space, which I think is so important, and why the Constitutional Case Conference is so useful. These things, of course, are not self-executing. And really what I wanted to do is thank my colleagues who have spent so much time putting this together, not for the first time, but again this year. Professors Ben Berger, Sonia Lawrence, and Kate Glover Berger, thank you for, what's that? Well, I knew you were here, but I know. Oh my God. So that's embarrassing. Most days I do screw something up, but I don't normally screw up the introductions as I'm looking at two people. Anyway, Emily and Kate, I'm sorry. So Professor Emily Kidd-White, who was organizing, Professor Glover Berger, who's going to do the lead lecture on summarizing the cases. I do know who they are. I just screwed it up. And thank you for saving me. Thank you to all of you, and also to our colleagues at Osgoode, Erica and Megan, and our team in our research staff. These things don't happen without them. So very much appreciate everyone's efforts. The good news about screwing things up at the beginning and putting the bar nice and low is now everything will actually look really good. So with that, Professor, do I hand it over to Professor Glover Berger or back to you?
Back to me.
Okay.
Yeah, thanks. Thanks, Trevor, so much. And we really are so pleased, Trevor, that you're able to make it. I know it's so busy and it means a lot that you came. So I'm just about to turn things over to Emily Kidd-White to introduce our year in review. But let me just say, you know, I did want to take a moment just to say a brief word of introduction of her as she sets us into motion for the content of the day. If you've been a long time attendee of con cases, but in the last number of years have noted an appreciable uptick in energy and depth in the event, that's all Emily. Really swiftly in this first many years of her career, she's established herself as a legal philosopher of international repute, as a tremendously insightful constitutional scholar. But I think it's really important to observe that in all of that, Emily's core interest is in how this bears on how people fare in their worlds, in their complicated lives. And that sensibility, combined with a very principled, very ethical, very caring way, is what so enriched our conference. And I hope you'll take this opportunity to just join me in thanking her for all of that as we hand things over for the schedule to her.
Thank you, Ben. What a lift at the end of term. So it is a wonderful personal pleasure first to be here and also to introduce my excellent colleague, Kate Glover Berger, who teaches constitutional and administrative law at Osgoode Hall Law School and who came to us as a multiple award-winning teacher and scholar from Western Law School. Professor Berger earned her doctorate from McGill University as a Vanier Scholar and in his under the leadership of the legendary Rod MacDonald. And I believe, as many in the room would agree with me, is following in his footsteps as surely one of the most interesting and innovative public law scholars in the country. She earned her LLM from Cambridge University, where she was the Right Honorable Paul Martin Senior Scholar and served as a law clerk for the Honorable Justice Rosie Abella at the Supreme Court of Canada. Kate is the academic chair of the annual Forum on Administrative Law and chair of the advisory board of the Canadian Association of Law Teachers. Professor Berger's scholarly and teaching experience lies in administrative and constitutional law. She has a paper that I absolutely love to read and share with others and teach, entitled The Constitutional Status of the Administrative State, in which she argues that the administrative state can now be understood as an architectural feature of our Constitution. Like all of Kate's work, it is so smart and thoughtful and rich in theory and detail. every year we get feedback that the year in the review is nearly everybody's highlight from the day. And so we have to invite somebody good. Kate was our unqualified first choice for the job, and we're so delighted she accepted our invitation. Please join me in welcoming Professor Glover Berger.
Good morning, everyone. It's so nice to see all of you. And thank you, Emily, for that very generous introduction. It's such a special quality when you can introduce a speaker and make them feel competent and capable and celebrated right at the beginning. And so thank you so much. I'll also say thank you to Emily and Sonia and Ben for inviting me to deliver the year in review this year. And really for all of their work on this conference. You know, I see firsthand that the work on this conference actually runs year round. As soon as this conference is over, they are shepherding the papers through the peer review process and publication process. And once that is over, the planning for next year's conference begins. So thank you so much for all of your tireless work. And I'm glad Ben said this. I don't know about Sonia, but I can say that since Emily joined the team, you know, the degree to which Ben is working so hard on this conference has gone down. I won't say how much. I will say as well that I was surprised, shocked to get the invitation to deliver the year in review. I actually had to send an apology to Emily and Sonia and Ben because of the strength of my reaction, but I have a very special place in my heart for close doctrinal analysis of the Supreme Court's work and for contemplating the institutional dimensions of the court and its work. And so I'm so delighted to have the chance to do that work here with you today. Following in the tradition of the year in review, my presentation today will cover both some quantitative institutional dimensions of the court and then speak to the substance of the court's jurisprudence in 2023. I'll also say that in the tradition of the year in review, I'm likely going to run out of time, but I'm going to do my best to fit my remarks into the time allotted. So let me turn then. Here are the things I'd like to cover, both the court's work and the court case's substance. And I'm going to begin by looking at these institutional and quantitative dimensions of the court's work. Before I do that, and again, because I'll likely run out of time, let me just say at the beginning, the photos in this presentation all come from the Supreme Court collection. I'd like to say a very special thank you to Zoe Bernickia Freeman, who was my RA throughout this project, and she is excellent. Also, thank you to Professor Sean Rahag, who I know will be here. Might be here already. He has this amazing Supreme Court of Canada bulk decisions data set. And one of my slides, and Ben says this is my most interesting slide, relies on the data from that data set. So thank you to Sean. Okay, so let me begin then with some comments on the composition of the court. So here's what the court looked like at the beginning of 2023. And during the year, we had one change to the composition of the bench. So Justice Brown began his leave of absence on February 1st, following a complaint to the CJC. Jamie Cameron went through all the details of the complaint and the proceedings in last year's year in review, and so I won't go through those details now. During Justice Brown's absence, many judgments were released in cases in which Justice Brown participated in the hearing, but he could not, because he was on leave, participate in the final disposition of the judgment. And so, in other words, this shows us that the court wasn't waiting for him to come back in order to continue to release judgments. There were 7 judgments that were released during his leave of absence, none of which were close in terms of the final outcome. So while we don't know how much his persuasive abilities might have had an impact on the outcome, at least his vote would not have made a difference in any of those cases. Justice Brown then retired in June of 2023, and 8 cases were released, 8 judgments were released after that, in which he had participated in the hearing, but of course could not participate in the final judgment. Again, 7 of those were not close. They were all unanimous or had a single dissent, except for one case, and that's the case, the Greater Sudbury case, which is a provincial offenses case, and the outcome was tied 4-4. And so obviously Justice Brown's participation could have and would have made a difference there. After Justice Brown's retirement, Justice Mary Morrow was appointed in November 2023. She has now been a judge for more than 30 years, and immediately before she was appointed, she was the Chief Justice of the Court of King's Bench in Alberta. On the Supreme Court, she has now participated in 14 hearings and 8 judgments. For all of those judgments, she has been in the majority or part of a unanimous court. She has not yet written any reasons, and she's only been on the court for 6 months, and so we wouldn't necessarily expect her to. So for next year's year in review, this will be a watching brief to see Justice Morrow's contribution to the court. So here we have the composition of the court now at the end of 2023 and still today. And so for the first time, you can see that the majority of the members of the bench of the Supreme Court are women. The first woman was appointed to the Supreme Court in 1982, Justice Bertha Wilson, and now 42 years later, there is a majority of female members on the bench. Over the past few years, there has been a fair bit of turnover at the court. So we've had appointments and retirements in 8 of the last 10 years. So let me just look at where we stand in terms of the composition. So, and this is, I'm looking at the length of how long the judges have been sitting. So we have 2 judges who have been sitting in that 11 to 15 years category. We don't have anyone who is currently in the category of Chief Justice McLaughlin, the 20-25 years of experience on the court. We then have 3 members who are in that middle band of 6 to 10 years, and then 4 judges who have been sitting on the court for 5 years or less. So right now we have this kind of mixed membership in terms of experience, years of experience. Likely a good thing, right? To have that institutional memory on one end, and then some new fresh eyes and new thinking who are on the court now. In terms of mandatory retirement, we could have a period of stability. We've had a lot of turnover. We could have a period of stability of 4 years if Justice Rowe stays until mandatory retirement. He is the next person who must retire in 2028. After that, 3 of the female members of the court must retire. After that, all 3 members from Quebec in about 8 to 10 years. In about 20 years, Justice Jamal must retire, and then this court will fully turn over in 25 years if Justice Obansawin stays until mandatory retirement. She must retire in 2049. So that's what the court looked like in 2023. Let me now turn to some of the quantitative features of the judgments from 2023. And one of the most prominent numbers that pops up is the number of judgments that were released in 2023. And the number is 34. Now, of course, that number is not significant on its own, but when we look at it in historical perspective, we see that it is historically low. It is the lowest number of judgments released in the modern period of the court. If we think of the modern period starting in 1949, when the court became the final court of appeal in Canada. Before the modern period, there were also 34 judgments released in 1879, right, in the early years of the court, as well as 1947, right after World War II. 34 is the lowest number of judgments since 1884. The record low, and you can see in the chart on this slide, all of the years in which 34 or fewer judgments have been released, the record low being 21 in the first 2 years in which judgments were released. And 34 is, more than 100 judgments, fewer than the record high of 143 in 1990. Now, this is the slide that Ben tells me is the most interesting, that comes from Sean's data. And this shows the number of judgments that were released by the court in every year since the court was established. And so you can see the trend in cases over time, with these dips in the early years of the court, in the years before and after World War II, and now we have 34 judgments, a very low number in 2023. We also see this peak of high output in the late 1970s, early 1980s, and then in the 90s as well. So what might explain this this low output for 2023, and is it significant? So thinking about explanations, I think there's an interesting socio-legal and political science question here about what's happening in the institutional biography of the court at these moments of low output, as well as high output. But let me work through some of the possible factors that might be contributing to this low output. One straightforward reason could be human resources, right? The court spent 10 of the 12 months of the year with only 8 judges, and with Justice Brown's leave of absence and then retirement, surely majority judgments had to be reassigned and hearing responsibilities shuffled. So that could certainly slow workflow and output. And indeed, I'll note as 2023 has the longest average time span between filing an application for leave to appeal and a judgment in the case. The average in 2023 was 20 months, whereas in the 9 years preceding that, the average was 16 months. So it is longer than usual. Another straightforward reason perhaps could be some trickle-down effects from the pandemic. Another hypothesis could be that the court was preoccupied with other elements of their judicial role, hearings, leave applications, and things like that. So let's look at those numbers. For 2023, these are all the cases that were filed at the court that had to be considered. And I should note here that there are 3 graphs in my presentation that are taken from the Supreme Court Year in Review, which the court releases its own statistics, and they released theirs a few days ago, of course, after all of my research had been done. But they have 3 graphs that are particularly helpful for me as I'm explaining some of these numbers. So the turquoise graphs are from the Supreme Court's Year in Review. So this slide shows the number of cases filed. You can see that the number of leave applications that the court had to consider was at 523, which is not an unusual number in terms of the historical data. It's up from the past few years, but nothing unusual there. I'll note here, though, that there is quite a meaningful dip in terms of the number of notices of appeal as of right. In 2023, only 10, which is a dip compared to the historical numbers. I haven't traced down the potential reasons for that, but I think there's an interesting question there. So nothing unusual in terms of the leave applications. We can then look at the outcomes of leave applications, right? If we look at the number of leave applications that were granted in the years preceding 2023, right, that would be feeding the hearings and the judgments for 2023, the rate was low in 2020, 2021, and 2022. However, if you look at let's look at 2022, there were 31 leave applications granted. And if you combine that with the number of notices of appeal as of right from 2022, which is 23, we don't have a court in 2023 with a docket that's particularly burdensome. So it's not that leave applications and the number of cases coming in is necessarily distracting the court. We could also think that hearings are preoccupying the court, but if you look at the numbers here of the number of hearing days in the year, 2023 is low. It's the lowest in the last 10 years, except for 2020, which for obvious reasons had a low number of hearing days. So what might be the reason for this. And of course, we don't know, but let's ask, is it significant? Well, if we look back at this slide that's showing all the judgments over the history of the court, we can see that if we extract the years around World War II, then we do have a general trend line going upwards from the beginning of the court up until the 1990s, and then a general trend line going down. My apologies, I should have inserted those trend lines into this graph. In that sense, if that's true, there was a general trend line up and then down, then 2023 might not be an anomaly. It might be simply a part of a pattern of lower output of the Supreme Court, and maybe perhaps we're in or entering a period in which the court might be quieter or more reserved. That being said, we could also be anticipating or just before kind of a boom year or a boom period. If you do look at, and again, I don't have a slide on this, but if you look at the number of cases going into the court, right, and that need to be scheduled and heard, and then the rate of judgments that are being released. And if you look at that year after year, there is a significant pool of cases that are in backlog, right, that haven't been considered. So if we're entering into a period of stability of composition of the court, perhaps we're in a time or about to be in a time where that backlog could be addressed and we could be on the upswing after 2023. Okay, let me look at some of the other quantitative numbers in terms of the judgments from 2023. And let me begin by looking at the rates of agreement. How often do these lovely people agree or disagree in their judgments? So we have 34 judgments, as I said, from 2023. Of those cases, 20 were unanimous and 14 had a dissent. I'll note that in the Supreme Court's numbers, they treat all judgments that are unanimous in the result as unanimous cases. But I do want to point out that of those 20 unanimous cases, 18 were unanimous in the result and the reasoning, and there were 2 in which there was a divide on the reasoning. Okay, so at least one concurring opinion. In terms of those 20 unanimous judgments, this graph shows the rates of agreement over time, the percentages of agreement over time, and 2023 is neither remarkably low nor remarkably high. So now let's look at these 14 judgments that had a dissent. So are divided in the result. And here, looking at who has been dissenting, we can see that Justice Cote is again the most prolific dissenting voice, and by far, right? And of those 9 dissents in which Justice Cote participated, she wrote 8 solo dissents where she was writing simply on her own behalf. And the last one was a joint dissent where she was writing as well. Justice Cote also has 3 solo concurring opinions in 2023, showing that she really does come at cases in a different way than her colleagues, whether in terms of the result or the reasoning or both. The other kind of notable number here on this slide is that Chief Justice Wagner did not dissent at all last year. He was always part of the majority or part of a unanimous court in the cases in which he participated. Let me just speak very briefly about majority cases, who is writing in for the majority. And here I'm really looking at workload distribution, right? So the key number in terms of majority opinions is 27. So, and let me explain that. There were 34 judgments from the Supreme Court in 2023. Of those, 24 had their reasons reserved, right? Disposition and judgment reserved. 10 were decided from the bench. Of those 10, 7 were the disposition and reasons from the bench, and 3 had the disposition from the bench and yet reasons were reserved. And so 27 is the number of judgments from the court in which reasons had to be written and released. So when I talk about majority judgments, I'm interested in this number 27. So here is a chart that shows who is writing for the majority or for the court. I've noted writing alone, solo majority judgments, as well as who's writing jointly. For the most part, there is a fairly even distribution of work. Each judge is writing or has been assigned 3 to 5 majority opinions. The one exception is Justice Obonsawin, who has 2 joint majority opinions. Of course, Justice Obonsawin has only been on the court for a year. She was appointed at the end of 2022. And so we wouldn't necessarily be surprised by this outcome in terms of when she is assigned majority opinions. Okay, let me look at the last quantitative feature that I want to look at in terms of the judgments. And this is showing the categories of law that are seen in these 34 judgments. So we have 34 judgments. Surprisingly, 32 of those judgments are public law cases. We have 2 private law cases, the green circles. So this is a perfect time to be thinking about the court's public law thinking and approach. Okay? And I'll note as well that there were 32 public law judgments released in 2023, so the court is really thinking about public law. And if we look at the judgments that have already been released in 2024, 12 of the 13 judgments from 2024 have been public law as well. And that includes the judgment that will be released today, which will be released in 4 minutes, about the breach of liability for the breach of treaty rights prior to the entrenchment of Section 35. So that will be released in a few moments. You will know the outcome before I do. So looking at these 32 public law judgments, 17, the blue circles, are constitutional law judgments, and we have 15 other public law. Breaking that down further, on the constitutional law side, we have 9 criminal cases that involve a charter issue, 2 division of powers cases, 2 charter cases, and 4 that I put in the other constitutional law category. I can show you what cases those are. Here are the categories and the cases that fall under each heading. In the other constitutional law category, I'm talking about cases, Hansman and Neufeld is a defamation case, but draws very strongly and requires thinking about, it's a slaps issue that has to be decided here. So the proper use of the courts in a context of freedom of expression and human rights. The open court principle, cases dealing with the open court principle, I also put in other constitutional law. And then Sharp is a case dealing with the jurisdiction of an administrative decision maker. However, it's a case about the constitutionally permissible reach, extra provincial reach of an administrative decision maker. And so it was a constitutional case. In terms of the other public law category, so we have 17 constitutional law decisions and 15 public law decisions. Of those, 12 were criminal cases with a non-charter, with no charter issue or no direct charter issue, and then 3 in the category of other public law. And skipping ahead here, in terms of the cases that went into this other public law category, Dean's Knight is a tax case, Mason and Canada is administrative law and immigration and refugee law, and Greater Sudbury is a provincial offenses case. I have to say that categorizing these cases was one of my favorite exercises in contemplating these, because reflecting on which case should fall into which category was surprisingly fun. And there is, of course, fluidity between some of these categories, and we could talk about some of the choices that I made in terms of allocations. And really, I think all public law, could go into the constitutional law categories. So I won't belabor that point, but interesting conversations on some of these cases and where they should be allocated. Okay, so let me now turn away from the quantitative assessment of the judgments from 2023, and let me now look at the substance of the cases and draw out some of the themes that jumped out to me as I was reading all of these cases. I'll say a few words about the structure of the Constitution, also the court's approach to analytical frameworks, and here really a mood of stability in analytical frameworks from the 2023 judgments. I'd like to point to some themes from the state of administrative law in the judgments coming out in 2023, and then just a few points about the 2024 constitutional and public law cases, as well as the things to watch for in the docket in 2024. So let me begin with the structure of the Constitution. So we have right now these 32 public law judgments from 2023 and 12 public law judgments from early 2024. What is the vision of the Constitution, or of the structure of the Constitution, that emerges from all of these cases, kind of thought of together? So I've listed here some of the cases that are most relevant to this issue in setting out a kind of vision of the structure of the Constitution right now. But let me highlight just a couple of points. So first, in this overall picture of the Constitution from 2023, 2024, we see a court that understands the Charter as having quite a broad reach, as well as a court that's recognizing the unwritten dimensions of the Charter in particular as having legal consequences. So two of the cases that I'll just highlight here on this point. First is the first case listed, which is Commission Scolaire. It is a case dealing with when an administrative decision maker has to consider the Charter in their decision making. Now, this was an interesting case to consider this issue because in Commission Scolaire, we have the minister in the Northwest Territories, the Minister of Education, Culture, and Employment, who had to make a decision on an application by 5 families for access to French language education. Now, none of these families who were applying at this time had Section 23 rights under the Charter. And so there was no Charter right that was directly engaged. The minister ultimately dismissed or denied all of these applications for these children to go to French language schools. This decision was challenged, and ultimately the Supreme Court of Canada unanimously held, and an administrative law decision that is unanimous is something unusual on its own, but the court unanimously held that the minister's decision in dismissing these applications for French language education were unreasonable. Why? Because the minister had failed to consider the purposes and values of Section 23 that underlie this decision. Okay, so even though Section 23 wasn't directly engaged, the minister was required to think about Section 23 and the purposes and values underlying Section 23 when making these decisions. The minister failed to do so, and so the minister's decision was unreasonable. Now, ultimately, by the time, of course, it got to the Supreme Court, these children were all in French language school, and so the outcome didn't have that implication for the families involved. But in terms of affirming this idea that the Charter reaches into administrative decision-making when a Charter right is not directly engaged and the unwritten dimensions of the Charter are at stake is worth noting. We also see in the very last case listed, Dixon and the Vuntut-Gwitchin First Nation case, which is from 2024. We see the same idea of the broad reach of the Charter coming out of the Supreme Court's understanding of the Constitution. Now, this is a case that I could spend all 45 minutes on. It will no doubt be the focus, a focus of next year's Concases conference, but let me just point to this, the Section 32 issue, Section 32 of the Charter issue. This was a case in which there was a Section 15 challenge to the Constitution of the Vuntut-Gwitchin First Nation. Okay, so we have a Charter challenge to the Constitution of a First Nation. And the preliminary question was, does the Charter apply here? Right? And the court concluded, the majority of the court concluded that the Charter does indeed apply. Why? Because, the court held, the government of the Vuntut-Gwitchin First Nation was a government in its nature, right? Thinking back to Eldridge and the ways in which Section 32 can extend its reach, what is bound by the Charter. One of the options is governments or entities that are operating as a government by their very nature. And the court held that here, this government was democratically elected, it was democratically accountable to its citizens, it had a taxing power, it could make coercive laws that bound its citizens, and as a result, its actions were bound by the Charter, including its constitution. And so the Section 15 claim could be considered. So we see here some examples of the court really extending the reach or understanding the reach of the Charter to be very broad. Another point to make here on the structure of the Constitution is that the court expressly and implicitly presents the courts as being very confident and autonomous and powerful when it comes to constitutional interpretation and judicial review. And a case called Yatar and TD Malashman X, which I can see now is not listed on this slide, is one key example. I'll come back to that case in a few minutes. But another case that really highlights the court's confidence in terms of constitutional interpretation is the second last case on this list, the reference regarding an act respecting First Nations, Inuit, and Métis children, youth, and families. In this case, we have the court, it's a reference considering the constitutionality of the act. And again, there are a number of issues here. Let me focus on the ones that are relevant here. So in this act, the Parliament did a number of things. First, it stated in the statute its own interpretation of Section 35, right? It said that it affirmed the right of self-governance under Section 35, and that right of self-governance included the legislative authority over child welfare. This act also stated that Parliament was incorporating the laws of Indigenous communities, certain laws of Indigenous communities, into federal law, and declared that in the event of a conflict between those incorporated Indigenous laws and provincial law, the incorporated Indigenous laws would prevail, right, in the event of a conflict. So these features of the act were challenged as unconstitutional, and the Supreme Court said, no, this is constitutional. Parliament can do this. Parliament can set out in a statute its own understanding of the Constitution, and it binds itself, Parliament and the federal government, in terms of acting in a way that is consistent with those statements, with those presented interpretations of Section 35 and of the incorporation of those laws. But the court said, that's fine, Parliament, that's great and constitutional, but in terms of authority over the meaning of the Constitution, Parliament, yes, that's cute, but we are the ultimate interpreters of the Constitution. We are the guardians, and regardless, Parliament, of what you say in your statute, we, at the end of the day, will decide the content of Section 35, what it affirms and what it doesn't. And so the court was really affirming its own power in terms of the Constitution in that case. Let me turn now to another substantive theme that emerges from the cases, and this is the court's stability in many of its analytical frameworks. This is not universal, right? And I'm sure this will come up in some of the panels later today. But in terms of a general mood, the court was unmoved by many of the critiques of its existing analytical frameworks and tests, and rejected invitations to rethink those frameworks. So again, I've listed some of the cases that are most relevant on this point. Let me just describe a couple of them. So the case of Hills is a Section 12 case, and I won't go into the details here because it is the subject of a panel later on. But on this point about rethinking analytical frameworks, and in particular, the analytical framework for thinking through when there has been when a mandatory minimum is inconsistent with Section 12. Justice Martin notes the strong critique of the court's current test for mandatory minimums in relation to Section 12 and says those critiques, those are exaggerated debates, right? She says, yes, this approach to Section 12 and mandatory minimums, yes, it requires the court to make judgment calls and to consider very fine distinctions between the effect and length of certain sentences. However, she says, that's what judges do. And so the fact that there is complexity in this analytical framework and some subjectivity in terms of judicial decision-making, she said that's not enough to change the analytical framework. And so the court went on to affirm the existing framework and elaborate it and offer guidance on how it should be applied. Another case in which we see this stability of analytical frameworks is the case of Commission Scolaire. This was a case which I've talked about already in terms of the French language education. On the legal point, though, in terms of the analytical framework, this was a case in which the Supreme Court was invited to rethink Doré, right? Doré, the case that establishes that whenever an administrative decision engages a charter value or a charter right, then the administrative decision maker must proportionately balance the charter engagement or the charter value or right that's been engaged and the statutory mandate. There has been extensive and deep critique of Doré over time. And so many expected that the court in Commission Scolaire would take the opportunity to rethink Doré and offer an alternative. Instead, the court unanimously affirmed Doré and brought it into the Vavilov era. Now, in taking Doré and bringing it into the Vavilov era, there is, an amplification of the reasonableness assessment under Doré, but in terms of the principles and the underlying approach, the court in Commission Scolaire was again unmoved by these critiques of Doré. A third theme to note are some developments in administrative law. And so these are the administrative law cases that the court released judgments in 2023 and in early 2024. So a number of them. I'm not going to go into the details of these cases as much as I would love to do, but I want to note that a couple of things to notice here. The classic administrative law appeal, right, the one that many of us would have become familiar with in law school, is a dispute about which standard of review applies and whether or not the administrative decision meets that threshold. Except for Mason, that we're not seeing that kind of classic dispute, that classic frame of case in the appeals of administrative law right now. Instead, many of these cases are dealing with other kinds of administrative law issues, and in particular, administrative law issues that are at the intersection of administrative law and constitutional law. Right? Again, Commission Scolaire, as we've talked about, is a key example there. Yatar and TD Insurance Malashman X is another example. This was a case in which, I'm looking at my 2 minutes. I could talk about this case forever, but I'll just say that this case deals with the question of whether or not an administrative decision maker whose statute says that the decision maker's decisions can be challenged by way of appeal on questions of law, right? So a limited right of appeal. The question is, can an individual who wants to challenge those decisions both appeal and access judicial review on other grounds? The Ontario Court of Appeal had said, yes, you can do both, but only in rare circumstances, in exceptional circumstances. And the Supreme Court of Canada, again, showing this confidence in judicial authority and their power of judicial review, said no. It won't only be in rare circumstances that you can seek both appeal and judicial review, right? Instead, of course, courts always have, the discretion in terms of whether or not to grant relief in judicial review, but those avenues are available. And the court didn't decide this on access to justice grounds. It was more framed in terms of the court's constitutional authority to exercise its power of judicial review. I'll just note here, right, final point, the public law cases that have been decided so far in 2024, many big significant cases, and these are the hearings over the next couple of months, and one that's pending at the top, all of which deal with major public law and constitutional issues. And while there were no Section 35 cases and Aboriginal law cases released or judgments released in 2023, the hearings and decisions in 2024 are already not at all making up for that, but we see the court having to engage with Section 35 and many different kinds of issues of Aboriginal law coming to the court. And I will end there. Thank you so much for listening.
Thank you, Kate. Just watching the room, I'm confident in speaking for everyone that we wish that went on even longer. That was just a fantastic year of review, and thank you. And I'd like to invite the panelists up for our first plenary of the day. Thank you.